Hi friends, today I'll just revise the previous question papers for our LLM first semester, Rules of Jurisprudence and Theories of Law. So first question, Philosophical School, also known as Natural Law School. The Philosophical School of Jurisprudence, also called the Natural Law School, believes that laws are derived from moral principles and universal justice. It asserts that legal rules should be based on the ethics, reason, and human rights rather than mere legislative enactments. So thinkers like Aristotle, Aquinas, and Locke argued that natural laws exist inherently in human nature and must guide human-made laws. In India, we can see that the influence of natural law is evident from preamble and fundamental rights of the Constitution. So especially Article 21, right to life and personal liberty. So the judiciary has often invoked natural law principles to interpret laws in a just and fair manner. So for example, if you look at Maneka Gandhi versus Union of India, the Supreme Court ruled that any law affecting personal liberty must be just, fair, and reasonable. And with this explanation, they expanded the interpretation of Article 21 and emphasized that procedural fairness is essential to law, reflecting the principles of natural law. While the school promotes justice and human rights, the critics of philosophical school of law argue that morality is subjective and varies across societies, so making natural law difficult to apply universally. However, it continues to influence constitutional and human rights jurisprudence in India. The second short answer is command theory of law. So the command theory was developed by John Hastings. It belongs to positivist school of jurisprudence. It defines law as command issued by sovereign authority backed by sanctions. According to Austin, law must have three elements. One is command from a sovereign, a duty imposed on people to obey it, and a sanction for disobedience. This theory focuses on law as it is, rather than what it ought to be, so separating law from morality. It sees law as purely a creation of authority, which must be followed regardless of its ethical value. So, for example, the case law in A.K. Gopalan versus State of Madras, the Supreme Court ruled that as long as a law is validly enacted, its fairness or morality is irrelevant. The Preventive Detention Act was upheld despite concerns about fundamental rights, aligning with Austin's idea that law derives authority from sovereign, not moral considerations. So while critics argue that this theory does not explain laws that exist without enforcement, such as customary laws, and fails to account for international law, which lacks a clear sovereign authority. However, it remains significant in legal positivism and statutory interpretation. It's the third short answer, social solidarity. This belongs to sociological school. So the sociological school of jurisprudence views law as a tool for maintaining social solidarity, and ensuring harmony within society. So the main thinkers in this school of law is Emile Durkheim, Roscoe Pound, and Dupit argued that law evolves with society and must address social needs rather than rigid legal doctrines. The school believes that law should balance individual interests with collective welfare. In India, this approach is reflected in laws that address social justice, such as labor laws, environmental protection, and affirmative action policies. Courts often consider social welfare in legal interpretation. For example, the case law Vishaka versus State of Rajasthan, the Supreme Court recognized the absence of laws on workplace sexual harassment, which led to laying down guidelines based on international conventions and social needs. So this case demonstrated how law adapts to protect societal interests. The school is criticized for prioritizing social needs over legal certainty, which may lead to unpredictable interpretation. However, it ensures that law remains relevant to changing social realities. The next is minimal state and law. The minimal state theory associated with libertarian thinkers like Robert Nozick advocates for a government that limits its role to protecting individual rights, enforcing contracts, and maintaining security. It opposes excessive state control over economic and personal freedoms, arguing that government intervention should be minimal. In Indian law, this theory reflects in policies promoting like liberalization, privatization, and deregulation. The shift from a socialist economy to a market-driven approach in 1991 aligns with this perspective. Courts have also upheld minimal state interference in private matters. For example, in Keshavananda Bharati versus State of Kerala, Supreme Court introduced the doctrine, ruling that certain constitutional principles, such as individual liberty, cannot be altered even by the Parliament. So this case reflects a limitation on state power, supporting the idea of minimal state. While this theory promotes economic freedom, critics argue that it may fail to address inequality, requiring some state intervention for social justice. A balance between minimal governance and regulatory oversight is necessary. Next, subordinate legislation. The subordinate legislation, also known as delegated legislation, refers to laws made by authorities other than legislature and powers granted by primary statute. It includes rules, regulations, and bylaws made by government departments, municipal bodies, and regulatory agencies. This ensures efficient governance as legislature cannot cover every detail. However, excessive delegation can lead to arbitrary lawmaking, reducing parliamentary control. The doctrine of excessive delegation limits the delegation of essential legislative functions. Courts in India have played a key role in striking down over delegation. For example, Delhi's Laws Act case 1951, the Supreme Court ruled that while delegation is necessary for governance, essential legislative functions, like making fundamental policy decisions, cannot be delegated. This judgment established limits on subordinate legislation. So while subordinate legislation enhances administrative efficiency, it must be exercised within constitutional limits to prevent misuse of power. Judicial review ensures that delegated powers are not exercised arbitrarily.